Hello everyone. So as mentioned earlier, we are going to start with Parliament chapter. We are going to cover this in two different videos, part one and part two, because it's a little bit longer and it will take a lot of time to cover in one video. So let's begin with Parliament. First of all, as we are already aware that there are three important arms of parliament, that is the Lok Sabha, that is the Rajya Sabha, and that is the president. So first important point is that. Now in order to proceed, better would be to go directly to bare act, to the Constitution of India, and see how parliament has been defined. So let's go. Yeah, so this is Constitution of India bare act, and let's go to the chapters where parliament is mentioned. Okay, chapter 2, that is Parliament of India. It is part of what? Part 5. Okay, so part 5 we have the union executive. First we have president and the vice president. President, executive power of the union, election of president, manner of election, terms, and etc. All of these related to president, vice president, council of ministers, attorney general, and conduct of government business. So we will do that later on. Let's look at the parliament chapter first, that is from article 79. Article 79, the parliament is mentioned in constitution. Okay, so let's go to the article 79 quickly. So these are 27, we are at 27. Let's go to 70, parliament. Okay, so this is 72, 75, 76, and 78 and 79. Okay, so this is 79 from bare act. You can use bare act, you can also use Lakshmikant for that matter, and see from 79. Okay, so I'm going to read these so that it becomes easier for you to understand from the bare act. It mentions article 79, there shall be a parliament for the union which shall consist of president and the two houses. So it is mentioned in article 79 that there shall be important word is shall. There shall be parliament for union which shall consist of president and two houses, to be known as Council of States and the House of People. Council of States is Rajya Sabha, House of People is Lok Sabha. Okay, very simple. 79, we are done with 79. Then composition of Council of States, that is composition of Rajya Sabha. Composition of Rajya Sabha. The Council of States shall consist of 12 members to be nominated by president. So 12 members are to be nominated by presidents in accordance with the provision of clause 3, with provisions of clause 3. First, second is not more than 238 representatives, not more than 238 of states and union territories, So member of parliament 238 plus 12. The allocation of seats, now we have with the clause 2. This was clause 1. As you can see, this was clause 1, clause 1a, clause 1b. Now we are at clause 2, 80 clause 2. The allocation of seats to Council of States to be filled by representatives of state and the union territory shall be in accordance with the provisions on the behalf contained in the fourth schedule. Okay, so fourth schedule of the constitution, as you are aware about fourth schedule, the 80 clause 2 of constitution states that the allocation of seats in Rajya Sabha is to be filled by representatives of states and union territories shall be in accordance with the provisions of the behalf, the provisions mentioned in schedule 4. Okay, nothing very difficult in this, easy to understand. We have understood two important clauses. Now let's go to the third. So as we have seen in this, is 80 clause 1. 80 clause 1 we have seen this here. 80 clause 1a, we have seen that the 12 members to be nominated by the president in according with the provision of clause 3. So let's look at clause 3. What does clause 3 says? Clause 3 is relatively simpler. It says that the members nominated by president under subclause A, as we have seen, of clause 1 shall consist of person having special knowledge and practical experience of such matters as the following. So the matters are described in the constitution. You should remember these matters. First is literature, then science, then arts, and then social service. So UPSC can ask such questions that literature, science, art and social service are not mentioned in constitution, but in fact they are mentioned in the constitution 80 clause 3. 80 clause 3. Okay, now you can see we have let me remove some of the parts. Now you can see we have some important footnotes here. That's why I ask everyone to do Bare Act, because there are a lot of footnotes in Bare Act which helps you remembering lot of things which are not which are usually missed by you. So first of all, let's look at some of the footnotes. Look at the footnote number 3. Footnote number 3, added by the Constitution 7th Amendment, Constitutional Amendment Act 1956. 7th Constitutional Amendment Act 1956 added clause 3. So where is 3? You can see right here it is 3. It is written 3. And the union territories. So earlier, before 1956, only states had representation. Only states had representation in Rajya Sabha. But with the 7th Constitutional Amendment, union territories and of union territories, this part was added. This part was added. Okay. So that's how you have to see. That's how you have to see the footnotes. Where are the footnotes? Right here it is written 3 and right here it is written 3. So it means that this part, this section after the 3 was added as it is written, added by the Constitution Amendment Act 1956. Okay. Then there is another. The word, let's look at 2. The word subject to provision of para 4 of 10 scheduled omitted. So we don't have to worry much about omitted. We only have to think about added or removed whatever was added or removed by Constitution Amendment Acts. Okay. 1 also you can find 2 and 1 as well. You can see there is, right here we have 2 here, footnote 2, and we also have footnote 1. Footnote 1 will be for above chapter. Okay. All right. 3 is also here. You can see 3 and of the union territories. So this was also added. This was also added by what? 7th Amendment Act. So that's how you have to see footnotes if you are reading Bare Acts. It is very important to see these footnote ones and specifically try to remember those which are Constitutional Amendment Acts, adding or removing anything from the Constitution. Okay, let's go to 80 clause 4. 80 clause 4. It states the representative of each state. Now we have first footnote. We will see it later on. Representatives of each state in the Council of State shall be elected by the elected members of Legislative Assembly of the state. Okay, so members of MPs of Rajya Sabha are elected by MLAs of states that they represent. MLAs of states that they represent in according with the system of proportional representation by means of single transferable vote. So what exactly is this type of voting? The proportional representation by means of single transferable vote. We will discuss it in later videos, but you remember that the Rajya Sabha members are elected by proportional representation by means of single transferable vote. Okay, you remember that. This is very important. You have to remember it. This may be asked in question. Earlier also in PYQs they have been asking this question regarding proportional representation by means of single transferable vote. You should know that Rajya Sabha members are elected by this process. Okay, let's go to 80 clause 5. 80 clause 5. What does it say? The representative of union territories in the Council of States, like the states like Delhi, Puducherry, shall be chosen. The union territories, the Rajya Sabha members from union territories shall be chosen such in manner as Parliament may by law prescribe. Okay, so the Constitution has not prescribed. For example, in this, for states, Constitution has prescribed that the process is proportional representation by means of single transferable vote by the MLAs. But in case of union territories, since union territories come under central government, they have mentioned it that such a manner as Parliament may describe. Okay, so there is two differences between 84 and 85. That is with respect to states. that is with respect to states and union territories. 84 is about MPs being elected in Rajya Sabha by MLAs of states with a means of proportional representation by means of single transferable vote. Whereas the manner for MPs from union territories is decided by parliament. 85 is done. Okay, so we have done 80. Let's go to 81 now. Let's go to article 81 now. Okay, 81. What does 81 talks about? It talks about composition of House of People, that is composition of Lok Sabha. Okay, it states subject to the provision of article 331. So remember that 331 puts a exception. That 331 puts an exception on 81. We will discuss 331 later on, and you should remember that. You should go and check out what 331 is about. Okay, subject to the provision of article 331, the House of People shall consist of, the House of People, that is the Lok Sabha, shall consist of not more than 530 members, not more than 530 members chosen by direct election from territorial constituencies of the state. Okay, we also have a footnote here, footnote number 6. We will see what footnote is about. Then 81 clause 1a. This was 81 1a. Okay, now we have 81 1b. Okay, this states that not more than 20 members to represent union territories chosen in such a manner as parliament may by law provide. As parliament, again the similar circumstances here has been created, that in case for states, the constitution has mentioned that direct election, but in case for union territories, it has mentioned that chosen in such a manner as parliament may by law provide. Okay, now we are at 81.2. It says that for the purpose of subclause A of clause 1, for this one, there shall be allotted to each state a number of seats in the House of People in such a manner that the ratio between the number and the population of the state is so far practicable same for all states. So what does it's trying to say? Let's read it again. There shall be allotted to each state a number of seats in the House of People in such a manner that the ratio between the number and the population of the state is so far practicably the same for all states. For example, it states that the constituencies, for example, if you are in Lucknow, the Lucknow constituency, if it has 20 lakh people, then around average all other constituencies across India should have around 20 lakh people. The ratio between the number and the population should be same. You should remember, this is very important. Try to understand what is trying to say, and remember, it is very important to remember certain aspects of polity. So these facts which I am trying to highlight again and again, you should remember. Why? Because it is directly mentioned in the constitution. Okay, let's go to 81.2 clause B. 81.2 clause B. This was 81 clause 2, clause A, clause B. Okay, each state shall be divided into territorial constituencies in such a manner that the ratio between population of each constituency and the number of seats allotted to it so far practicable be same throughout the state. Okay, this is also very important. These are two types of ratios that it is talking about. You should figure out what it is about. Okay, you have to find out and mention in the comment of the video what these two are and give examples of it. Okay, and give examples of it so that you understand it and others also are able to understand it. I am going to do it again when we do the parliament chapter, but for now this is your homework, that you have to find out what these 81.2 and A and 81.2B, what kind of ratios is it talking about. Give some examples and mention it in the comments. Okay, now let's go to the this is also B part. Provided that the provision of subclause of A of this clause shall not be applicable for the purpose of allotment to this House of People to any state so long as the population does not exceed 6 million. That is 60 lakh. That is 60 lakh. All right, this is an exception. You should know that 60 million, if the states exceed 60 million, that does not apply. That does not, this does not apply. So lot of footnotes here. So you should remember some of them. I think we don't need to remember, because all of them are substitute. This means substituted. So substituted, again substituted. So nothing was added or removed. So we can there is nothing we should remember from these footnotes in this chapter. Okay, now go to the 81 subclause 3. 81 clause 3. In this article, the expression population means by the population as ascertained by the last preceding census. Okay, last preceding census of which the relevant figures have been published. Provided that the reference to this clause to the article clause to the last preceding census of which the relevant figures has been published shall until the relevant figures for the first census taken in year 2026 have been published. Okay, so these are conditions for how population is to be ascertained. What will we use, what figures, what data will we use for finding out population. Okay. For the purpose of subclause A, article 2, provision of clause 3, reference to 1971 article. Okay, 1971 census. For the purpose of subclause B, clause 2 as reference to 2001 census. Okay, so you can see 81A, 81 to A we have this, and for 81 to B we have this. You go and read what is 81 to N again and try to match what is it talking about. All right, let's go to 82. I am trying to quickly go through all of these because you will be doing these by yourselves, and it is important that if you are not able to understand anything, you have to find it on the internet. Okay, you have to find it on internet, find any videos which are able to explain this, because my goal here is not to teach you but to make you understand how you go through these documents, how you approach, what is your methods, how you should read Bare Act, what are the processes you should follow it, my understanding, and how I can help you in finding that approach. All right, so let's go to the 82, article 82, that is readjustment after each census. Upon completion of each census, the allocation of seats to the House of People to the states, that is Lok Sabha, House of People is Lok Sabha, and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as Parliament may by law determine. So this is talking about what? Delimitation Commission. This is talking about delimitation commission. It does not mention delimitation. All right, Constitution does not mention delimitation. It mentions by such authority. This authority is delimitation commission, and Parliament usually forms it. Provided that such readjustment shall not affect representation in the House of People until the dissolution of the existing house. So okay, so if a Parliament is in session, the present session is going on, it cannot affect the representation. It will happen only after house is dissolved. Okay, provided further that such readjustment shall take effect from such date as President may by order specify, as may President may by order. Okay, so the authority that will decide the readjustment of seats and into territorial constituencies is decided by Parliament. Parliament is decided by Parliament, but once the authority, that is delimitation commission, has decided the parameters and all the taking all the data population into account, what eventually will take the effect, that is the readjustment shall take effect from such a date as president. Okay, so here the authority is by the Parliament, or authority is decided by the Parliament, such a manner as Parliament may determine, whereas the date on which the readjustment shall take effect, that is decided by the President. Okay, any election to the House may be held on the basis of territorial constituency, such election before the. Okay, this is that. Provided also that until the relevant figures of the first census taken into the year have been published, it shall not be necessary to readjust What is the allocation of seats of the House of People as readjusted on the basis of 1971 census? Second, the division of each states into territorial constituencies readjusted on the 2001 census. So there is a difference here. 1971 we have allocation of seats. Okay, but when it comes to territorial, each state into territorial constituencies, allocation of seats, but 2001 is being used for division of each state into territorial constituencies. All right, so let's go to 83. So 83 is about duration of parliament. The council of states, that is Rajya Sabha shall not be subjected to dissolution, cannot be dissolved, but as nearly as possible one third of the members therefore shall retire as soon as may the expiration of every second year, in accordance with the provision made by parliament. So parliament will make law regarding this. The House of People, that is Lok Sabha, unless sooner dissolved, shall continue for 5 years. We have a footnote here. Let's see footnote. It is very important. Footnote: 42nd Amendment Act 5 years, further substituted by 44th Amendment Act for 6 years. Okay, for 6 years. So 42nd made it 6 years, and 44th made it again 5 years. Okay, so now it is 5 years. From the date appointed for its first meeting, and no longer expiration of the said period 5 years shall operate the dissolution of the House. So it says that 5 years is the term of parliament. Lok Sabha, not parliament, Lok Sabha. Provided that the said period may, while the proclamation of emergency is in operation, be extended by parliament by law for a period of not exceeding more than a year at a time, and not exceeding any case beyond 6 months. Okay, so when proclamation of emergency is there, when emergency has been proclaimed, the parliament can be extended not more than 1 year, and it cannot continue for 6 months. After the proclamation of emergency has ceased to operate. After emergency has finished, it cannot be extended more than 6 months. Okay, right? Let's go to 84. Qualification for the membership of parliament. A person shall not be qualified to be chosen to fill a seat unless he is a citizen of India, which means that a person to be chosen a member of parliament should be a citizen of India. He has to make and subscribe before some person authorized on the behalf of the Election Commission of India on oath and affirmation according to form set out in the third schedule. So even those who are contesting, very important, you should remember that not only MPs, but candidates who are fighting for MP have to subscribe this oath. This is in the third schedule. It is mentioned in third schedule. You should remember that. Very important point. This is very important. Wherever things are important, I am going to mark a star. You should remember these things. In case of the seat of Council of States, now we are for Rajya Sabha not less than 30 years of age. 30 years of age. And in the case of seat in the House of People, not less than 25. So Lok Sabha 25. Very easy. You already know this. Possesses such other qualification. So there have been debates regarding whether there are qualification criteria for being elected as a member of parliament. As of now there is no, but parliament has mentioned here. You can see possesses such other qualification as may be prescribed in behalf and under any law made by parliament. So constitution gives power to parliament to prescribe any other qualifications required to be member of parliament, but parliament has not made any such law regarding qualification to be a member of parliament. Let's go to 85 now. 85, session of parliament, prorogation and dissolution. Okay, the president shall from time to time summon each house. The president shall time to time summon each house of parliament to meet such a time and place he thinks fit. Okay, so this is important. Why am I marking this? Because it gives the freedom to the president to to summon of the meeting of the parliament at such a time. First it's mentioned such a time, which means that at such a time as president may decide such a time. And then it also mentions and place, which means that not only Delhi, if president says that let the parliament will meet in, let's say, Vishakhapatnam, then they have to meet it, because constitution gives that authority to president, because such a time and place he thinks fit. Okay. Next point is 6 months shall not intervene between its last sitting and one session, date appointed, first sitting and the next session, which means that between two sessions, that is, let's say this is budget session in March, and then we have monsoon session in August. So this is in March, that is 3rd, this is in 8th. So 6 months should not be in between. 6 months should not be in between. Okay. Then what is 85.2? President may from time to time prorogue the house of either houses. President can prorogue house. What is prorogue? You have to find out. What does prorogue means? You have to mention it in comments. What does prorogue means? Okay. Dissolve the house of the people. So it is only for house of the people that can be dissolved, as we have already seen that Council of States, that is Rajya Sabha, cannot be dissolved. Let's go to Article 86 now. Right of president to address and send messages of the house. This is very important because PYQs, if you look at PYQs, questions have been asked in prelims from this president's address. Every year in January this address happens, and the president tries to cover all important topics, all important initiatives, all important schemes, all important everything that happens in 1 year under the government. President tries to cover in their address, and this has been a very good source for preparation for prelims related current affairs as well. Okay, so what does 86 says? The president may address either house of the parliament or both houses assembled together, and for that purpose require attendance of members. The president may send messages to either house of the parliament with respect to bill then pending in parliament or otherwise, and house to which may message is to be sent shall with all convenient dispatch consider any other matter required to. Okay, so president, two things for president. First is that it may address either houses or both of them assembled together, and secondly it can send messages. Okay, then we have the special address. This is the special address. This is what I was talking about here. Okay, this is what I was talking about here. At the commencement of first session after each general election to House of People, and the commencement of first session of each year. So there are two conditions here. Okay, you can see there are two conditions here. First condition is after Lok Sabha election. The first session. Okay, and second is each year. President has to give the special address. It is written special address. Okay, so you have to star mark it here. Every year January this special address happens. Okay, the president shall address. It is written shall. It is not may address. It is shall address, which means the president has to address. In this case the right to address, it is written may. You can see it is written may address, but here it is written shall address, which means these two addresses, that is at the commencement of the first session of each general election and at the commencement of the first session each year shall address both houses of the parliament assembled together. In this case both houses has to be assembled together and inform parliament of the causes of its summon. The president also has to inform why president has summoned the gathering. Okay, provision shall be made by the rules regulating the procedure of either house of the parliament for the time and discussion matters referred to. Okay, so what happens is when president has given this address after 87, there is a short session to thank the president. Okay, and in that the provisions are made, rules regulating the procedure either house of the parliament, allotment for time of discussion. In that various member of parliaments participate in discussion and debates on various issues that are pertaining to very important nature. Okay, so that's it regarding president's address. Let's go to 88. Right of ministers and attorney general with respect to houses. Every minister and attorney general of India shall have it is written shall have the right to speak. First of all, right to speak, and otherwise take part in proceeding of either house. Either house. So for example, if a minister is not a member of Lok Sabha but a member of Rajya Sabha, not a member of Lok Sabha, not a member of Lok Sabha but a member of Rajya Sabha, and he is if a is made a minister, is made a minister from Rajya Sabha, he can participate, she can participate in both Lok Sabha and Rajya Sabha, can participate in the proceedings and speak in the proceedings of both Rajya Sabha and Lok Sabha. Same goes for Attorney General. Attorney General is not a member of either of the houses, but yet Attorney General has the power, has the right to participate and speak in the proceedings of either houses, or any joint sitting, any committee which he may be named a member, but shall not by virtue of this article entitled to vote. Shall not. What does this mean? This means, let's say, if a minister is from Rajya Sabha, they can participate in Lok Sabha. Only ministers, not MPs. Only ministers can participate in Lok Sabha, but cannot vote. It is written shall not. It is written shall not by virtue of this article. That is this 88 article. By the virtue of this 88 article, shall not be entitled to vote. Same goes for Attorney General. Just because this article states that they have right to speak does not mean that Attorney General has the right to vote. Vote in the proceedings. All right. I think it is fairly easy. Let's go to 89. We have the officers of Parliament. Very important. This is one of the favorite topic of UPSC, and repeated questions have been asked in this as well. Let's go to 81. The chairman and the deputy chairman of Council of States. That is chairman, that is the vice president, and deputy chairman is the deputy chairman of Council of States, that is Rajya Sabha. So vice president is the chairman. You are already aware about the vice president is the chairman of the Rajya Sabha. It is written the vice president of India shall be ex officio. Ex officio means by the virtue of holding that chair. For example, vice president is holding the chair of vice president, so he is the ex officio chairman of Council of States. The Council of States shall, it is written shall, as soon as may be, so which means there is no timeline. It doesn't mention 6 months, 5 months, 2 months, 1 month. It says as soon as may be, choose a member of council to be deputy chairman thereof. So Council of States, that is Rajya Sabha, will choose deputy chairman, and so often the office of deputy chairman becomes vacant. So if office of deputy chairman is vacant, we have to write vacant. If office of deputy chairman is vacant, the council shall choose another member to be deputy chairman. So council will choose another. Can choose another. Okay. So this is what 89 is. This is what 89 is about. Okay. Let's go to 90. So 90 is about what? 90 is vacation, resignation, removal from the office of deputy chairman. Okay. So this is regarding vacation, resignation, removal from the office of deputy chairman. A member holding office of deputy chairman of Rajya Sabha, that is Council of State deputy chairman, shall vacate his office if he ceases to be a member. Okay. So if Rajya Sabha decided that this member will be the deputy chairman and he loses his membership of the Rajya Sabha, he will vacate his position as deputy chairman. Sec B, 90B is may at the any time by writing under his hand addressed to chairman, that is vice president can resign. May be removed from his office by a resolution of council passed by a majority of all the then members. You should remember this. This is very, very important. This is super important. It is written all the then. You should remember all the then. What kind of majority it is? It is called effective majority. Effective majority. It is called effective majority. I am going to star mark it again with a different color so that you remember this. This is very, very important. This line is super important for deputy chairman removal. Or majority of all the then members of Rajya Sabha. Majority of all the then members. This is constitution. It is directly written in constitution. Okay. Provided that when the removal such resolution for the removal, provided that no resolution for the purpose of clause C shall be moved unless at least 14 days. 14 days. So if someone wants to remove the deputy chairman, they have to bring in a resolution and give 14 days notice, notice given of the intention to move. Okay, that they are going to move a motion resolution, they should give 14 days notice. All right, I think it is clear. I think it is. If I am going too fast, if I am missing things, if you think this is not the right way, please comment, and I will try to take your feedback and improve. Okay, let's go to 91. That is the power of deputy chairman. Deputy chairman is Rajya Sabha. Again, deputy chairman is Rajya Sabha and other person to perform the duties of the office as to act as chairman. So this is regarding when deputy chairman will act as chairman. This is regarding deputy chairman act as while the office of chairman is vacant. So it is written vacant. Remember that there is a difference between vacancy and absency. There is a difference between vacancy, that is being vacant, and being absent. Okay, so you have to be very careful. What is it talking about? It is talking about vacant or during any period when the vice president is acting as or discharging the function of president. Okay, so the first condition is when the office of chairman is vacant. Okay, so office of chairman is vacant, or when the vice president is acting as president. Okay, that also means that the office of chairman is vacant. The duties of the office shall be performed by deputy chairman. The deputy chairman will act as chairman when these two conditions are there, or if the office of deputy chairman is also vacant. Okay, if the office of deputy chairman is also vacant, by such a member a council of state as the president may appoint. Okay, this is very important. Again, when the office of chairman is vacant, or during any period when the vice president is acting or discharging the function of president, the duties of the office shall be performed by deputy chairman. Duties of what office? Duties of chairman office. Or if the office of deputy chairman is also vacant, deputy chairman office is also vacant, by such a member of the council, such a member of Rajya Sabha as the president may appoint. This is regarding vacancy. Remember that 91 is regarding vacancy. Vacant. Remember that. 91.2 is absence. 91.2 is absence. During the absence of chairman from any sitting of the, like for example, chairman is the office of chairman is not vacant but absent due to some reasons, the deputy chairman, or if he is also absent, if deputy chairman is also absent from the sitting, such person as may be determined by the rules of procedure of the council, that is the rule of procedure of the Rajya Sabha, or if no such person is present, then any other person may be determined by council. Okay, so this is regarding absency of chairman and deputy chairman or any other member. So there, these 91 and 91.2, first is vacancy, second is absency. You have to be very careful in what they are trying to ask, whether they are trying to ask regarding vacancy or they are trying to ask regarding absency. Okay, they may try to confuse you, flip these statements, put these statements here and put these statements here. So you should be very careful of what they are talking, whether they are talking about absency or they are talking about vacancy. All right, let's go to 92. The chairman or the deputy chairman not to preside while the resolution of the removal, as we have seen the resolution of the removal for deputy chairman, resolution for removal of deputy chairman we have seen. So what does it say? At any sitting of the council of states, that is any sitting of the Rajya Sabha, while any resolution for the removal of the vice president from his office is under consideration. So during the sitting of Rajya Sabha, if there is a resolution for the removal of vice president, the chairman, for the removal of vice president the chairman, or while the resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman shall not. So it says that when the removal of vice president is under consideration in Rajya Sabha, or when the resolution of deputy chairman removal is under consideration of the Rajya Sabha, both of them they can be present. Shall not, it is written shall not. Okay, I have just somehow managed to clear it. Okay, so it is written shall not, it is written shall not, though present. He can be present, but he cannot preside under the provision of clause 91 shall apply in relation to every such sitting as applied to relation sitting which maybe deputy chairman is absent. All right, so main condition is the vice president removal resolution is in place. Removal resolution is vice president can be present in the house but will not preside the sitting. Preside matlab he won't act as chairman when the resolution for the removal is there. Same goes for deputy chairman. When the resolution for the removal of deputy chairman is there, he may be present in the house but he will not preside the sitting. He will not be sitting. Okay, another, the chairman, whenever chairman is says, it means Rajya Sabha. Chairman shall have the right to speak. Okay, shall have the right to speak and otherwise take part in the proceeding of the Council of States, that is Rajya Sabha, while any resolution for the removal of vice president from his office is under consideration, but notwithstanding anything in article 100, shall not be entitled to vote at all. Okay, this is very important. When the removal of vice president is in consideration, when a resolution for the removal of vice president is in consideration, he first of all he may be present in the house. Second of all, cannot preside the meeting. Third, he has the right to speak. But he cannot vote at all. Why at all? Because vice president is not a member of Rajya Sabha. That's why he cannot vote. In such a resolution for the removal is in proceeding. Okay, very simple, nothing difficult. Read again. These are very important chapters. You have to read again. Okay, let's go to 93. Speaker and deputy speaker. Now we are talking about Lok Sabha. When speaker and deputy speaker comes, it is Lok Sabha. When chairman, deputy chairman comes, it is Rajya Sabha of the House of People. The House of People shall, as soon as may be. Here also there is no timeline. It is not written within 1 month, within 15 days. It is written as soon as may. Choose 2 members. So which means both of them are chosen together. Of the House of respectively as speaker and deputy speaker thereof. So often as office of speaker and deputy speaker becomes vacant, the House shall choose another member to be case. Whenever it is written vacant, so when there is vacancy, the House shall choose. Okay, let's go to 94. That is vacation, resignation, removal of office of speaker and deputy speaker. Okay, that is Lok Sabha. A member holding office as speaker or deputy speaker of the House of People shall vacate his office if he ceases to member of the House. Okay, if so, since MPs are elected and from MPs we elect the speaker and the device speaker, if they cease to be member of parliament, if they cease to be member of the house, not parliament, member of House of People, they have to vacate the office of speaker and deputy speaker. May at any time by writing under the hand address, if such member is speaker will write his resignation to deputy speaker, and if such member is deputy speaker, it will write to speaker. Okay, so speaker will give the resignation to deputy speaker and deputy speaker will give resignation to speaker. Okay, this is what 94B is talking about. May be removed from his office by a resolution of House of People passed by majority of all the then members. Again important, that is effective majority. We have to remember effective majority, that is all the then members. Very very important, mark it again, all the then members. Here again all the then members it is mentioned, provided that no resolution for the purpose of clause C, that is this is clause C, shall be moved unless 14 days notice has been given for intention to move such resolution. Very simple. provided further that whenever the House of People is dissolved, whenever House of People is dissolved, it is written dissolved, not prorogued. Dissolved, the speaker shall not vacate. Speaker shall not vacate his office until immediately before the first meeting of the House of People after dissolution. Okay, okay, it's very simple. You already know about it. Let's go to Article 90. Let's go to Article 95. 95. Power of Deputy Speaker or other persons to perform the duties of the office or to act as a speaker. While the office of speaker is vacant, again the same circumstances, vacant and absence. Two different terms. Very careful. UPSC can flip these terms and try to confuse you. Okay. Office of speaker is vacant. It is written vacant. The duties of the office shall be performed by deputy speaker. Or if the office of deputy speaker is also vacant by such a member of the House of People as president. Again, we have, when there is a vacancy on the both of the deputy speaker and speaker, the president may appoint such person for this purpose. This is for vacancy. Remember, vacancy. This is regarding vacancy. Next is what? Regarding absency. Again, absency. During the absence of speaker from any sitting of the House of the People, a deputy speaker, or if he is also absent, such person may be determined the rules of procedure of the House. If no such person is present, such other person may be determined by the House. So when there is a vacancy, you should remember president. If both speaker and deputy speaker are vacant, then president will decide. And in absency, when both speaker and deputy speaker are absent, then rules procedure, that person is also absent. If that person is also absent, then as House will determine who will be the chairman or the speaker. All right, very important. Again, 91 A and B. Similarly, what we have seen here in Rajya Sabha, vacancy and absency, similar condition we have here in Lok Sabha as well. Let's go to 96 article. That is the speaker or the deputy speaker not to preside while the resolution of the removal from the office is under consideration. Okay, we have already understood in terms of Rajya Sabha. Let's look at the Lok Sabha case. At the any time sitting of the House of the People, that is Lok Sabha, while any resolution for the removal of the speaker from his office is under consideration, the speaker, okay, whenever the removal, okay, what is happening? Okay, whenever there is a motion to removal motion for speaker, what does it says? The speaker, or while any resolution for the removal of deputy speaker from his office is under consideration, the deputy speaker shall not, though present, and provision of constitution shall apply in relation to it. Okay, so both of them cannot preside over the such meeting when the resolution, they cannot preside. This is 96. The crux of 96 is they cannot preside over the meeting. They cannot sit as chairman and speaker when the resolution for the removal, when the resolution is under consideration. Okay, the speaker shall have right to speak. And otherwise take part in the proceeding of the House of the People while any resolution from his removal if the office is under consideration of the House, and shall, notwithstanding anything in Article 100, be entitled to vote only in the first instance. This is the difference between Rajya Sabha removal and Lok Sabha removal of the speaker. This is the difference. This is the key difference here between how we remove the chairman from Rajya Sabha and how we remove the speaker from the Lok Sabha. So in case of Rajya Sabha, we had already seen, since vice president is not a member of Rajya Sabha, he is not entitled to vote at all when such a resolution for the removal of chairman is under consideration. Not allowed to vote, not at all. It was written not at all allowed. But in case of speaker, since speaker is member of Lok Sabha, he is allowed to vote. But whenever such resolution for the removal is there, he can only vote in the first instance, which means he cannot vote as a tiebreaker. Usually the speaker has the power to act as a tiebreaker in normal circumstances. But when the resolution for the removal is under consideration, he cannot he cannot act as a tiebreaker, but only in the first instance. Is written first instance, very important. So any other manner presiding of the equality of votes, not in the case of equality of votes. Okay, so he has to vote not as tiebreaker. He has to vote not as a tiebreaker. Now we are at 97. Now we are at 97. As you can see, salaries and allowances of the chairman and deputy chairman and the speaker as a, there shall be paid chairman, deputy chairman, council of states, speaker, deputy speaker of house of such salaries and allowances as may be fixed by parliament by law. Okay, so the question can be asked, the president determines the salaries of speaker, deputy. No, it is the parliament. It is the parliament until the okay, it is in second schedule. It is in the second schedule. Secretariat of parliament, each house of parliament shall have separate secretarial staff, provided that nothing in this clause shall be constituted to preventing the creation of post common for both houses. Parliament may by law, again Parliament may by law regulate the recruitment and conditions for the service of persons appointed to the secretarial staff of either house of the parliament. Until the provision is made by Parliament, the President may consultation with Speaker, House of the Speaker and Chairman, the Council of the State may case may by regulating the recruitment condition, etc., etc. All of these facts are given right here. So we are already at Article 98. Let's go to Article 99. Okay, Article 99. Oath and affirmation of the member. Every member of the either House of Parliament shall before taking his seat make and subscribe before the President or some person appointed in the behalf of him an oath or affirmation according to form set out in the third schedule. So oath and affirmations are in third schedule. You should remember this. All right, let's go to Article 100. Article 100, what is it about? Voting in the House, power of Houses to act notwithstanding vacancies and quorum. Save as otherwise provided in this Constitution, all questions at any sitting of the House or joint sitting of the House shall be determined the majority of more member present and voting other than Speaker and the person acting as Chairman. Okay, so it is written that the all matters are decided by majority of votes. It is written any sitting house shall be determined by majority of votes. Other than, it is written other than speaker or person acting as chairman, they should not vote in instant. The speaker and chairman or person acting as shall vote in the first instant. Shall not. Okay, it is written shall not. My mistake. It is not shall. It is rather shall not. Shall not vote in first instance, but shall have exercise casting vote in case of equality. Okay, in case of equality. But when the resolution for the removal of Speaker of Lok Sabha is under consideration, they will vote in first instance. This is an exception here. Okay. Either House of the Parliament shall have power to act notwithstanding any vacancy in the membership thereof, and any proceeding of the Parliament shall be valid notwithstanding that it is discovered subsequently that some person who is not entitled to do so had voted on the proceedings. So not very important. So it is talking about if they discovered that there is a person who is not a member of and had voted, what can it be? Until the Parliament by law otherwise provides the quorum to constitute a meeting of the House shall be 1/10. So quorum is how many members are required for the proceedings to continue. That is 1/10 of 545. Right? It is footnote 1. Let's see what is footnote 1. Omitted by 42nd Constitution Amendment Act. This omitted by 44th. So this is omission had happened. So we don't need to remember that. Okay. If at any time during the meeting of the House there is no quorum. So 1/10 member are not present in the House. It shall be the duty of the chairman or the speaker of the president acting such either to adjourn the House or to suspend the meeting until there is quorum. I think this is enough. We have done up to 100 article. We'll do rest of them and rest of the in the next video. All right. Hope to see you for part 2.